lawyers before the commission, we feel that sometimes this issue needs to be addressed at a very threshold stage. There may be a situation where if cross-examination is permitted at an earlier stage, the outcome by the DG, the outcome could be quite different. And there may not be a 26-1 order, it may result in a 26-2 order. So as far as we are concerned, how does the bar and the bench evolve a system where we have a more robust system, which is, of course, both inquisitorial as well as adversarial, and which also takes into account principles of natural justice?
See, we have to take the formality out of the system. The formality of the court has to be taken out of the system, which we are failing to do from any of the forums and tribunals. There should ideally be hearings before a hearing, pre-chamber hearing as we call it in some jurisdiction, to tell each other to have a frank and fair discussion and see that, look, okay, this way it can be resolved, this is your doubt, this is what I'm willing to put forth. The matter can be ended at that stage. And that, as I said, you have to evolve, because this is a business related forum. So we have to, in fact, I hesitated from saying that. What I had noted down is that maybe we need a bar of practitioners. Maybe it should not be called the Competition Law Bar Association, it should be the Competition Law Practitioners Association. I have had experience in 3 arbitrations with the Bombay lawyers. They have technical lawyers, technical people who are unassisted by lawyers in these construction contracts. And I felt handicapped. I had to tell my client that, look, I can't face them. You have to get technical people. And it worked out much better. So maybe we need that common sense kind of a thing that maybe law, LLB degree is not essential for practicing in this field. We can have agents over a period of years in labor law. If any of you have experience, agents have developed and they are doing a commendable job. That there in any case. So maybe if I shed our band and the black coats, we'll be more amenable to the commission and DG. That's just one of the things, but can be done. Yes, Mr. Srinivasan.
My fundamental belief is that all of us agree this is an extremely unique position where we have right to CCI, the DG's office, the higher judiciary, the practitioners, all of us together. And I completely endorse and be grateful that the lordships have mentioned that this is an area where we don't need to convince each other. So it is really, the CCI is now tasked with finding from, and South Asia, LPG, the High Court had read all of that, saying that what is the difference between an inquiry and what an investigation is. The investigation proceeds on fact finding. Now, if the root is bad, the fruit will naturally be bad. So therefore, the commission finds, in my course of experience before the commission also, I find that the commission is handicapped sometimes because it does not find that there has been adequate or a robust investigation by the DG, even though there are many instances or there may be an indication. So really speaking, what is it that all of us are trying to do? We're trying to come to the truth of the matter. And therefore, it is important that we have the investigation at the fact-finding level very clear. So there is no need for us to have in law saying cross-examination. The DG himself should feel that if I need to find this is the truth, I should be impelled to test the veracity of what statement I'm recording by Mr. A, so that it is rebutted by Mr. B or there is corroborative evidence in some other form. If he doesn't do that task, sometimes because he's constrained by time, he has to go back to the CCI, then he finds, well, let this be now tested at the inquiry stage by the commission itself, and there'll be lawyers there, even though I don't call lawyers here, and they will thrash it out. And then the commission now finds, oh my God, we've got questions that this cross-examination has not been done. What do we do? Should we send it back, or should we rely on this incomplete data that we have? And that is the escalating factor. It ultimately goes down and we have a process failure. So therefore, to follow and to submit, in addition to what falls from your lordship, is this. My suggestion would be that the Commission has the powers of regulation and to frame regulations. This mutual consent business can happen if we were to submit whatever our suggestions are to the Commission. The Commission frames regulations permitting as a formality and as a guidance to the DG also. And that is followed, of course, in a time constraint. It hasn't to be an abuse. A good DG can go ahead and say, I will allow cross-examination, but I won't allow this facility to be abused. And if he's assisted by able lawyers himself at that stage, then the lawyer for the DG would be able to object if there is something that goes on endlessly. And I think that is extremely important. The DG level at this stage, he is not assisted by competent lawyers. And therefore, the effect of the bar would be manifold. Therefore, there'll be a bar that represents the interests of not just the CCI, but the DG also. Ultimately, we must make sure that we arrive at the truth. And I suggest that we relook the regulations, and that is within the purview of the CCI. Again, we are happy to assist and make sure that the bar is representing both the CCI as well as the private side. So it is not as if it is anti one or the other. So therefore, in our interest, it is important that ultimately this is done as quickly as possible.
That's right. I think with the presence of Justice Mittal and the direct DG is here, that they'll consider these suggestions. Somebody else wanted yes, please.
Paku Khan, Kethanika. Can you hear me?
Yes, certainly.
You can hear me, okay. I just wanted to follow up on Christian's comment about Germany versus the EU in terms of access to the file, where you said Germany, everything is open, EU, there's redactions. I think we both have been involved in cases in the EU where there has been a data room where lawyers and economists can actually come in EU cases and see that redacted information. So Christian, from you, I'd be curious to see how that actually has worked in practice, whether there are leaks, whether there's breaches of the contracts that the lawyers and EU economists have to sign. And to the distinguished panelists from India, I'd like to also get their thoughts on how that actually might work in the Indian context.
Thank you very much for this question. There has been a frequent concern that if unredacted information is made available to outside counsel and economic experts, that there would be leaks. But to my experience, this is not happening. First, there could be severe sanctions against outside counsel who breach their confidentiality obligation and who leak information to third parties or to even their client if they're not allowed to. And also, I think there is a common understanding that it is so crucial to get full access to file, or at least largely access to file, so that this in practice does not really happen. And I can only encourage a system where access to file is granted to the largest possible extent, because as I said, the basic principle should be only defense counsel can decide what is useful for their defense. And from that principle, it's clear that defense counsel needs to get access to, ideally everything. There is case law in Germany, for example, that lawyers who disclose confidential information that has been made available to them for the strict purpose of exercise of rights of defense, that they can be punished even criminally. And I think this is deterrent enough.
Yes, please.
My name is Dhanendra Kumar. Am I audible?
Yes, very much.
My name is Dhanendra Kumar, and I happen to be the first chairman of the Competition Commission. I have one or two observations to make. I completely agree with Justice Endlaw's observation that it would be very useful to arrive at some kind of a consensus during the proceedings of the case. And this brings me to the point which I considered earlier, but somehow we didn't have any system either in our law or in subsequent development of regulations. See, out of the various, let's say about 12 to 14,000 crores worth of fines imposed so far by the CCI, the actual recovery would not have been more than 1% or 2%. The whole thing goes on endlessly in appeals and subsequently. What I feel, and I agree with you here, that if we could draw a leaf from the European Union and FTC and DOJ in America by having some kind of a system of either settlement or commitment in EU and US, and my friends would bear me out. In the case of cartels and antitrust, there is a provision and it has developed over a period of time of having a settlement and a commitment. This brings finality to the cases in midstream, and this also helps in correcting the practices in the market and also recovering the amount which has been agreed to, and everybody is happy. So my feeling is that if we try and develop something of that kind, it would help in bringing finality to the cases earlier than what is happening at the moment. What do you feel about it?
I can't agree more with you. In fact, I feel that the Commission should not be looking at headlines of orders passing fines of hundreds or thousands of crores of rupees. The Commission should see its role as to set right the ills in the system and to set in place the procedures by which the ills, all right, even if they have happened in one situation, would not happen in another. So the Commission should be looking at itself slightly different, rather than it's not a contributory to the state coffers. It should not be looking at it like this. It should be looking at that what practices it can put into place to ensure that in future such a situation does not arise. And that can happen only if, and I'm sure that once a finding of culpability has been arrived at, the industry itself would see that that kind of thing does not happen. And what, if I understand you correctly, what you are saying is a kind of plea bargaining kind of a thing, situation. That's I think we've already overshot by 10 minutes. Since Mr. Chaudhary and Mr. Billy Moria have not had a word, I would request both of them to sum up.
Thank you. What I said about the taking cue from the discussion, I think an order, consent order, that is what I think Mr. Dhanendra Kumar has been referring to, which we have also quite a number of times from the bar or from us requested that whether or not we can have a regulation to that effect, that the parties have agreed outside and the Commission agrees to that settlement. Unfortunately, we have to then draft the regulation in that manner, because currently the regulation 30 of the CCI's regulation says even if the parties want to withdraw from the complaint, the CCI would proceed with the matter. So naturally, we have to tweak our regulations in such a manner so that the settlement, consent orders become a talk of the CCI. It is agreed that it is not a debt recovery tribunal. It is definitely trying to remedy the market distortions. So naturally, we have to harmonize. That is what is, I think, the order of the day. We have to see that the Commission's order and the DG's investigation are in harmony. Even if the parties are willing to settle it outside the court, it must be upheld in appeal. It should not be said to be that the settlement has really gone wrong. So we are in the process of evolution. The regulation making power is with the CCI. It must not supersede the substantive law, because that again becomes a problem. So this is, I think, the way forward for us, and it is good that we have discussed all these issues here. And I think we will be taking a takeaway from this, and that would be the best, to my mind, for the CLBA to take it forward. As we said in the inaugural session, there should be some summing up of our discussions for the day, and I think we can do that as part of our summing up.
Thank you, Mr. Chaudhary. Mr. Billy Moria.
So very quickly, As far as confidentiality of information is concerned, I think the controversy is more around what should be afforded the right to keep confidential, not really to, confidential information, even if it is marked as confidential, is made available to all the parties. So that's not really the issue. The issue is how do you decide whether something is confidential or not? As far as cross-examination is concerned, the key issue here is, will the CCI, I understand that, it's arguable whether the DG has to follow rules of natural justice. And again, if you take the example of the CBI as an investigator, or in fact, no other investigator is required to follow the rules of natural justice. But when the report of the CBI comes to the trial court does conduct the cross-examination. Now, the issue really is one of practicalities. Do we want a system where each and every matter must undergo the rigor of a cross-examination, even though it may not be necessary or not be asked for? I don't think so. And that's my own personal view. I know many of you will differ. The limited point I was making is that the test should not be, do you admit or deny? The test really should be, am I in a position to controvert a statement which has become known to me only once I get the DG report. So I get the DG report and I realize that there's a statement. That statement is not backed up by any documentation. And moreover, that statement is made by a party who is adverse to me, or whose commercial interests will lie if I'm found to be in contravention. In that circumstance, almost certainly a cross-examination should be allowed.
Thank you, Mr. Villimoria. So, if I understand correctly, and then I would request the President of the Bar that the outcome of this session or this theme can be, as far as procedure and natural justice is concerned, to resolve rather than litigate. If the litigation emanating from the proceedings before the Commission is minimized to the procedural aspect, I think it would be beneficial to all concerned, and we would be able to deal with the substantive issues of competition, which at the moment, and antitrust, which at the moment are being kind of deferred, and the fear is they may be deferred endlessly. Thank you very much. Thank you, Justice Mittal. Thank you, Mr. Chaudhary. Thank you, Mr. Villimoria. Thank you, Dr. Steinle. And thank you to the House. I think the participation has been excellent.
So now we have lunch that's on the second floor. So, but since we're a little late, we request that the next session starts at 2 p.m. So, request all of you to be here by 2 p.m. And as regards penalties, I believe the Competition Commission has not been able to recover a lot of money. How about 500 and 1,000 rupee notes?
So thank you very much.